Mr. Keeks is out.
Okay, if we could have the quasi-judicial announcement from our attorney and the swearing in of speakers.
Sure thing. This is a quasi-judicial proceeding where the Board of Commissioners acts, Board of Adjustment acts in a quasi-judicial rather than legislative capacity. At a quasi-judicial hearing, it is not the board's function to make law, rather to apply the law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the board is required by law to find against the applicant.
The swearing.
And will witnesses stand up, please? And would you raise your right hand? And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Thank you. Tonight we have before us application number 24-82, a variance to allow a non-conforming lot of record to be built upon for the purpose of constructing a single-family home. And we'll hear presentation from Ms. Ally Keene.
Okay. Ally Keene, Principal Planner at the Planning and Zoning Department. The subject property is highlighted here in red. It's located off of North Diston Avenue, just north of East Center Street. This property, as well as all of the surrounding properties, are in the R70A Single Family Residential Zoning District. And again, the applicants are requesting variance approval to allow a non-conforming lot of record, which is Lot 4, that was under common ownership with an adjacent property to the north, which is Lot 3, to be considered a separate buildable lot. And this is for the purpose of constructing a single-family home on Lot 4. The Land Development Code states that if at any time the owner of a non-conforming lot of record owns adjoining land, the lots must be combined to meet the minimum lot requirements. The R70A district requires a minimum lot area of 6,500 square feet, a minimum lot depth of 80 feet, and a minimum lot width of 60 feet. The subject property meets the minimum lot area and depth, but it is non-conforming by 2 feet for the lot width, and it's only 58 feet wide. There's a little bit of history with this particular application and why it's before the board tonight. There's a provision in the Land Development Code for deviations of 5% or less of normal zoning requirements that allows us to process a de minimis variance or an administrative variance. If there are no letters of objections that are received from adjacent property owners, then the city manager or the designee, which is the planning department, is able to approve the variance without it coming before the Board of Adjustment. This application qualified for that process, so we continued with that process. So on December 9th, we provided due notification to the adjacent property owners, and they were sent notification, and they had a 15-day notice period to provide a letter of notification, or letter of no objection. That 15-day period ended on December 24th, and we received no objections at that time. Then on December 30th, we issued the administrative variance approval, and the applicant could proceed with their construction plans. A few weeks later, on January 15th, the planning department received a letter in the mail, and it was an objection letter for this application. Even though this was outside of the 15-day period, we noticed that there was a date on the letter, and it was postmarked within that 15-day period. It was dated December 15th, So we informed the applicant of this, and then we also provided a letter to the property owner and informed them that they could appeal the application within a 60-day period of the administrative variance approval to the full board for review. And then on February 28th, that adjacent property owner submitted their second objection letter, which forwarded the application to you guys today. So looking at some site history, this property was originally platted back in 1907, and it was a part of the original plat of Tarpon Springs, specifically Lot 4 of Block 26, and this is the plat here on the screen. And this predates any sort of zoning regulations in the city and before any sort of land development code went into effect, which was in 1944. The property did not become non-conforming until 1976, and this is when a new land development code went into effect, and it placed the property into the R70 district. And that's when the 60-foot minimum lot width went into effect, and that became non-conforming at this time. Then in 1990, our current land development code became effective, and again, the minimum lot width of 60 feet still applied, and therefore the property is still non-conforming in lot width. As far as common ownership, lots 4, which is the subject property, and lot 3 to the north, were previously in common ownership. However, as of January of this year, the lots are no longer under common ownership, and the applicant owns the subject property. With regard to common ownership, one of the considerations of the board is whether or not the improvements on the adjacent property were reliant on the vacant property in order to develop. The existing home on Lot 3 to the north was, according to the property appraiser, built in 1935. This again predates any sort of zoning regulations for the city, so there was nothing in effect at that time to determine. But when looking at the R70A setbacks that we have in place today, the minimum side setback is 7.5 feet. So looking at the survey that was provided, the existing home has a side setback from that shared property line, which is the one that applies. It roughly has a setback of about 8 feet. It ranges between 8.1 and 8.3 feet. So if this structure was built today, looking at that side setback, regardless of the properties being combined or not combined, it would be compliant with the side setback, so it was not reliant on that adjacent property, or would not be reliant. These are your standards to review for non-conforming lot of record, and I am happy to take questions.
Thank you. Does anyone have any questions for our staff tonight? Yes, Mr. Grossman?
I have a couple of questions. The first one, I noticed in our packet that we have 3 criteria in the review standards, and in some of the other packets, there's 5 review standards. Because this is it de minimis? Is it because it's that type of, that we have 3?
So there are actually, not because it's a de minimis, but I'll touch on that. Different types of requests have different sets of criteria. The criteria here is specific to non-conforming lots of record. So when you're reviewing an application for this type of request, these are the criteria that apply. What you typically see with the 5 criteria are for most of the variances that you look at, which are more like setback variances, height, things like that. The de minimis variance also has a set of criteria that we look at that is slightly different, but depending on an application, sometimes criteria changes. But these are the criteria that apply to your request that you're looking at.
Okay, thank you. I have another question. So in reviewing all this, it looks like this request for the variance to build the home would be approved, actually administratively approved, not even have to come before us because it's such a small amount that it's off. And the real only reason that we're here is because there's an objection to the application?
So from staff's, well, it met the criteria to be processed for a de minimis variance because it was less than 5% deviation. But staff has to also look at the criteria under de minimis variances. We determined that it did meet those criteria. So we believe that it could met those and we could approve it. But part of that process is providing notification to adjacent property owners. And in that process, it says if a letter of objection is received, then it is forwarded to the board. This is just unique because it was over the holidays. We believe that's why the mail was delayed, because it came afterwards. We provide that the 60-day normal appeal period for them to get back to us and see if they wanted to object.
Okay, so if there was no letter, this would have been approved?
Correct.
Okay, and then one more question. I notice on page, it has a page 10 of 29 on it, one with the 8-foot. Put that back up.
Yes. Sorry. This one.
So I noticed that in the material, I think one of the objections was that it was, that the subject property was adjacent to another one used for the approval. And in this case, it was not, because the only way that it would not have been approved if that was less than 8 feet.
So this, because the home was built prior to any sort of zoning regulations, you can't say that it was reliant on the property to the south or not. We don't even know if these two properties were in common ownership when the house was built because of the records. But looking at what the current requirements are in our code today, the minimum side setback is 7.5 feet. So I was just pointing out that the existing home, it exceeds what the minimum requirement is.
Okay, so it really, it didn't need the other lot ever to,
It wouldn't need it today.
okay,
Yeah.
thank you.
Yes, sir, Mr.
Haley, when was this lot actually just repurchased?
I don't know when it was purchased. January, I believe, is when it was finalized, but I'll let the applicant kind of talk about specifics on that.
Thank you.
You, Mr. Wood. Jackie, you have any?
Yes, ma'am. Thank you. So a couple questions. So do you happen to have the lot width of lots 3 and 5, the lots to the north and south of the applicant's lot?
They're both 58 feet.
They're both 58 feet. And you already clarified the 7.5-foot side setback requirement. Okay, and the properties the homes built on lots 3 and 5 both meet those?
So we only are looking at lot 3 because that's the lot that was under common ownership. I can't speak to lot 5. We don't have that information.
Okay. And in the notices that were sent to the adjacent property owners, that was sent on December 9th. So it's sounding like you sent those notices to lots 3 and 5 that had the side shared boundaries, adjacent properties. There's also properties that that are adjoining on the rear. Were those notified?
Yes, so we provided, let me go, I don't know if I have a good
be-
map. So, sorry. So notification was provided, because at the time,
29, maybe?
this property and this property here, we're under the same ownership, even though the applicant was different. So we notified adjacent properties around these two lots. So this property was notified, I believe, this one, this one, this one, and then we go across the street as well. So I believe these two were
Oh, really?
notified as well.
Across
I
the
can't
street.
remember if this one on the corner was, but we go on all sides.
Okay.
Yeah.
Thank you for
Adjacent
that
goes across the
clarification.
street. And
Okay.
alleys.
And the letter of objection, is the property owner of lot, are we permitted to know that information?
I believe it's lot 5 to the south.
Lot 5 to the south? Okay.
Anything else, Ms. Turner?
Not at this time, thank you.
Ms. Keen, just for clarity, tonight we're just approving or denying a variance to see if this is a buildable lot, correct?
Correct. If
Not
it meets
dealing
those
with
3
any
criteria.
setbacks, and it's up to them to come back with their plans to the planning office,
Correct.
correct?
If you determine that it meets the criteria for a non-conforming lot of record, they would have to build under the R70A setback requirements. If for some reason they were unable to do so, they would have to come before the board for any sort of variance request.
Okay, thank you. And that gets to your comment too about why the criteria is a little different. So, okay, perfect. Thank you. With no further questions, thank you, Ms. King. Do we have the applicant present? Yes, sir. If you state your name for the record and just the fact that you were sworn in and address.
Pantelis, Master Vasilis, 58 West Center Street. Yes, I was sworn in.
Thank you.
I build a lot in Tarpon Springs. The name of the company is called Tarpon Springs Building Company. A lot of your old lots are pretty much non-conforming. And never really ran into any problems, actually prior to this. But we're not asking for no setback variances. We're gonna go with that. And I build historical looking homes, so it's gonna blend in. And, I think it'd be a great addition to the neighborhood. And we own the lot now. So if you have any questions, just let.
Thank you, sir. Any questions for the applicant? Seeing none, thank you for being here. Okay, do we have any of the members of the public who would like to speak tonight? Yes, sir. When you approach, if anybody else who'd wanting to speak to, can we have the attorney swear them in? Maybe they can be sworn in at the same time and then you can take turns speaking.
Or just
You
if you
can-
both,
you
if you
just
both just
both
want to get
raise your
sworn in
hand.
at the same time?
Yeah.
Do you both swear to, or do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. And yes, sir, you first. And just please state your name and your address.
My name is Rory Kamenitsky. Our address is 255 North Distant Avenue. It is the lot located 2 lots north of the lot in question. So you have what was the joint property, and then we're next to it. Living in this neighborhood, my wife has been there for over 20 years. I've been there for about 14 myself. With this being said, we obviously have our little boy here as well, and I can only talk about what a great neighborhood that this is. We're friends with all our neighbors behind us, all around us, all the surrounding properties, as she had indicated. Several of our neighbors, they attend the same school. Some are a little bit older and attend the other schools. We're kind of the home in the neighborhood that is known for doing decorations and stuff during the holidays, and other homes are known for other things. And so we draw quite a good gathering of other kids and children, and we just grown very fond of that neighborhood. And knowing that's centrally located to the nice shopping districts, you have the Walmart, you have Publix, and some auto care centers, and obviously it's right down the road from the downtown Tarpon Springs area. We, instead of having a vacant lot, we would greatly welcome another, family home to the neighborhood, and another family that can share the great experiences that we have living there. I also think that it would be beneficial to sprucing up the neighborhood with something a little newer, and while still blending in with the current neighborhood. And I think it's just going to be beneficial all the way around. I mean, it's someone else that can enjoy the wonderful perks that Tarpon Springs has to offer, including close proximity to downtown. We have 4 churches, I believe, nearby, 2 located off the same road, off of Diston, as well as 4 schools between the Catholic Church School at St. Ignatius, and then our son, which attends Christian Way Academy. And then obviously you have a United Methodist and Tarpon Springs Elementary School. I just think it'd be a wonderful area for a family to move into and have that same opportunity and same experience that we have.
Thank you, sir. Yes, sir. Please state your name and address for the record.
Charles Augsbach, 1441 Wakeman Drive, Tarpon Springs.
Thank you, sir.
I'm the owner of Lot 5, and I had submitted the denial because of the 2-foot rule. I know the owners own Lot 3 and 4. Lot 3 was no electricity, no water, just a vacant house. And one of my objections was that I would have to be looking out my bathroom window right into the house next door. And that's, if they were fixing up Lot 3, I would be happy too, but it's a vacant one, no water, no electricity, full of bees. And like I
Okay.
said, I submitted the letter on time.
Yes, sir, we received it. Thank you. Okay, anybody else for the record like to speak tonight? Anybody online? No?
Oh, we don't have Zoom.
No, no Zoom? Okay. Okay, then I'll close public comment on this time. Anybody, any conversation with the board or someone want to make a motion?
I have a question. Can we question Mr. Osback? I don't know if I got your name right.
If it's for clarification, not really a back and forth.
So there's no,
If you need clarification on something, he said, or,
yeah, I would like to have a question to him.
okay. Which resident?
Mr. Osback?
Mr. Osborne?
Yes,
Okay.
yeah. Okay, so in your letter, you stated that, field adjustment review, per plan review, you're stating that it was meant to be not built upon.
Yes, at that time, Rick Jones was the owner of the properties, and he had his built already, he was on Lot 3.
But,
And Lot 4 was just between us as a buffer zone.
Well, all right,
But
so
he's
what
not that lot. Mhm.
so what my question is, how did you determine that that lot was not supposed to be built upon?
In a personal relationship with the owner, Rick Jones, and myself, when I bought the property. I bought the property, I think it was 91, let me see.
Oh, you probably don't need a documentation. So
92.
it was through a conversation,
Yeah.
not a legal document, or you don't have any documents that?
No, I don't think so.
Okay. I just wanted to know where you got the idea that it wasn't going to be, it shouldn't be built
Knowing the
upon.
owner and
Through
talking
a
to him.
conversation with the owner. Okay, thank you.
Okay, any other board conversation for us?
No, I can make a motion.
Okay, Ms. Turner?
I'd like to make a motion to approve.
I'll second. Go ahead.
Second.
Okay, thank you. Can we have roll call?
Is that Ms. Turner the motion and Mr. Wood the second?
Yes.
Okay, thank you. Mr. Wood,
Approve.
Ms. Turner,
Approve.
Mr. Grossman,
Approve.
Ms. Rich?
Yes, approved. Okay, thank you very much. Do we have any, we have the one set of minutes before us for tonight. They were the February 26 minutes. I did notify the secretary that she had called me chair already. She had called Jackie chair and myself chair. Do I hear anybody approving, make a motion to approve the minutes with that one correction?
I will make a motion to approve with the edits regarding current chair's title referenced in the meeting, in the minutes.
Do I hear a second?
I'll second.
Thank you. Roll call?
Mr. Wood,
Approve.
Ms. Turner,
Approve.
Mr. Grossman,
Approve.
Ms. Rich?
Yes, approved.
Okay, so I'll make that correction and then reprint the first sheet.
Sounds good. Okay, staff, do you have any comments for us tonight? Happy March.
I do not have any comments. I thank you for being available for this meeting. I know I announced at the February meeting, we did not have a March meeting, so thank you for being accommodating.
That was your April Fool's
It-
joke.
yeah, I guess it
just
was an
1
April
week
Fool.
early.
I
1
think I
week
told you
early.
literally like the day before, so I apologize.
No worries.
Do we have anything on the docket for next month?
I can't remember.
I believe we do.
I think we do. Remember. Oh,
So stay tuned. Keep it
believe
on
so.
your
I think we
calendar.
do.
Keep
Yes.
it on your calendar.
Oh, yes, we do. We do.
We do. Okay, thank you, and thank you to our attorney present tonight, filling in, so thank you. Anybody else? No? I will adjourn the meeting at 6:55 PM.
Or next month, I mean.
May.
I think the real question is, can you get an answer to it
Oh, no,
before
I-
tomorrow?
No,
Or is it gonna bother you
I
all
know.
night?
I know. I was gonna advertise it early. That's why, because it's what I want